How are you beautiful tubers doing? Thanks for stopping by, checking out my video here. It's been a while since I've done one of these. Please hit the like, subscribe, all those YouTubey things. Appreciate you. Trying to get to 8,000 subs. We hit 8,000. Do an 8-hour stream. Got a Lego train I'm gonna put together. And I don't know what other content we're gonna have, but right now, those of you that have been following the channel know that I've got an interest in this Turtle Boy predicament, the witness intimidation and all that. And anyway, I started doing some research on it, and the thing that gets me is the constitutional aspect of it between freedom of speech, freedom of press, and right to assemble, and all these things. I know some of these don't apply in situation because it's a strict the Constitution is written, it's our rights against the government. But it's also uh, these are some of when you talk about freedom of speech, you're talking about values that are uniquely American. And if you're at a dinner table and someone tells you to stop talking, you feel offended because it's without thinking about it, you just blurt out free speech. That's how ingrained it is in America. It's a um, It is definitely a right given to us by our creators. And when you talk about Massachusetts, it's very upsetting. It's a state I've never been to, but I have great respect for it. It's the cradle of America. The revolution wouldn't have started but for Massachusetts. And these are things all Americans are interested in, not just people there. And feel bad whenever I just only seen the Constitution disrespected. So let's talk a little bit about free speech. Free speech, um, as hold on here. Do I have my thing right? Yeah, I do. I have this recording. Sorry. Um, how do I do that? Yep. Free speech, as protected by the First Amendment, generally allows individuals to express opinions, criticisms, or even offensive ideas without government interference. Right? That's the hang on a second here. It's been a while since I've done a video. I'm looking at the all the fun little new things that StreamYard's put up. I apologize there. Like I said, you should check me out on a on a live sometime where it gets really fun. Um anyway, sorry. Where was I? First Amendment generally protects individuals to express opinions, criticisms, or even offensive ideas, right, without government interference. However, this protection has limits. So I was talking about earlier, particularly when speech crosses into categories like true threats. All right. The Supreme Court has defined statements where the speaker communicates a serious expression of intent to commit unlawful violence against a person or group, placing them in fear of bodily harm or death. True threats are excluded from the First Amendment protections. This is Brandenburg v. Ohio. I think that one. No, it's Brandenburg, Ohio. No, it's not that one. It's the Illinois Nazi case. I've always called it the Illinois Nazi case because it's Blues Brothers, right? But it was, I'll think about it here in a second. The name of the case, does the KKK have a right to have free speech to go out and march and stuff? And Supreme Court said yes, they do, but you can't threaten somebody. You know, you can't have a true threat. Can't cause fear, and you know there was a potential for actual violence. But witness intimidation, here we go, specifically occurs when such unprotected speech or conduct is used to tamper with witnesses, victims, or informant in legal proceedings. All right. So this is what I'm just kind of, going. There's an early idea where I want to go with everything. We start off with, is it a true threat? And then that's where you go into your witness intimidation. All right. This is the Turtleboy debacle. Don't forget about that. Federal law 18 USC 1512. You guys care? Told you I've been working on this stuff. Includes knowingly using intimidation, threats, physical force, misleading conduct, or corruption to influence, delay, or prevent testimony in an official proceeding, or to cause someone to withhold information from law enforcement. Right now, but some people that don't like Turtle Boy will just jump on and say, "Well, there it is. There's your answer. It's over with." You have to look at it as, was there any delay or prevention of testimony? I don't know. I haven't gone into the case. I don't know the case. Um, can you prove any of that? That's the part. It's you have to remember that whenever you think you have something in the law, you have to look at the other side of the argument. So whenever there's a yes, there's also a no. Remember, if you ever been to a law library, they're huge, huge, right? Just all these books, they're full of cases, and 50% of the people are wrong. Um, so you got to delay or prevent testimony in an official proceeding in order to cause someone to withhold their information from law enforcement. And then, of course, you guys know state laws vary, but everything kind of follows a similar principle. Um, like, for example, Ohio prohibits knowingly attempting to intimidate a witness after a police investigation or legal proceeding has begun, requiring a nexus between the speech and the intent to hinder justice. Now, the boundary is determined by context, including intent of the speaker, whether the statement was meant to intimidate or was mere hyperbole, artistic expression, or political commentary. Mere hyperbole, artistic expression, political commentary. Think about those three things. Uh, so here another case, Virginia v. Black. The Supreme Court ruled that cross burning done with the intent to intimidate qualifies as a true threat and is not protected. Get that? Okay. Cross burning is not protected speech. A lot of people say flag burning is protected speech. I think for me, that's when you can start seeing the gray areas there, right? You see how, well, okay, cross burning. Well, yeah, you shouldn't be able to burn across. We have those Hollywood images of a cross burning in someone's yard. Um, the KKK and violent racism of the 1960s. Um, it's uh, it's horrible, and you don't want to protect that. But then you start not protecting some things. Where does that line get drawn? It's a difficult thing. Uh, cross burning is not protected. It has a historical context of instilling fear, specifically in seriousness. Vague or conditional statements like political rhetoric. Oh, this is there's like case Watts v. United States, where a draft protester remark about the president of the United States was deemed hyperbole. Okay, you got a lot of cases where you have draft dodgers. They're burning their draft cards and all that other stuff, and then you know they get arrested, and then it became is the speech. Well, direct personalized threats are not protected. So a direct threat against the president is not protected. but a remark about him is just hyperbole. Reasonable perception rule. Okay, so the reasonable perception rule. Courts consider whether a reasonably prudent person, right? You've heard that, would view the speech as a genuine threat, factoring in the audience's reaction and surrounding circumstances. Connection to a proceeding. Okay, so is it a genuine threat? Right, that's one thing that we're looking at, and I'm not going to make a decision. I don't know Turtle Boy. I'd love to talk to him sometime, but I'd talk to him about like, okay, so why the Turtle Boy? Why is that? What got you into social media? I care more about interviewing people to know what they who they are than one little blip on their timeline. Uh, how's the audience reaction? Surrounding circumstances. You factors in, and then you have connection to the proceedings, right? Think about that one. So we have to apply it to the proceedings. And I may be wrong on all this. This is just a general idea. Started working on it so much. I was like, dang it, I'm gonna make content out of this. The speech must aim to affect a witness's role in an ongoing or potential legal matter, not just general harassment. Okay, now some of eh, I don't have the resources currently to find, more specific rules and whatnot. But again, this is just a broad understanding of witness intimidation and free speech, right? Um, so in Commonwealth v. Knox, which is a Pennsylvania, the Pennsylvania Supreme Court, which doesn't apply to Massachusetts, right? Upheld a conviction for witness intimidation and terroristic threats based on rap lyrics that named police officers as witnesses in a prior case and described violent acts against them. The court found the lyrics constituted a true threat due to their specificity, lack of broader commentary, and the officer's reasonable fear, rejecting arguments that artistic form alone provided First Amendment protection. I think you understand that, right? Everybody should understand. Artistic form alone. Just saying, I'm an artist, so I can come in here and dress like a naked monkey and read books to children. Right? We've seen those pictures, right? That's not free speech. That would be called perversion. Um, the U.S. Supreme Court declined to review, though, that Pennsylvania case. Okay, Pennsylvania v. Knox. Um, but there, the distinction. Let's see how much further I got my notes. I'll be able to wrap up everything at the right time. Ultimately, the distinction hinges on whether speech is protected expression or crosses into criminal conduct. So this is going to be the big distinction here. What is speech and what is like witness intimidation, and this is a vague thing. I'm not saying any of this stuff is right. Do not take anything I say is right. I've never practiced in any of this stuff. I do not have a license to practice law. I am not an attorney. Okay, you're none of that stuff. I am an overeducated uh, meatbag. That's all I am. All right. uh, the distinction is on whether speech protected expression or crosses into criminal conduct designed to obstruct justice. Courts evaluate these cases factually, often requiring proof of intent beyond just offensive words. Okay. So it goes back to I, on Broken Baker's stream. I think it was the December 20th, was it? I met Turtle Boy. I didn't know I was even meeting him, right? And we're having technical difficulties because Baker had changed his streaming platform. I wasn't prepared for it. My screen just showed up blank. I could see everything around it. I could see chat, but I couldn't see the camera. And I'm just sitting there listening to Turtle Boy, and I heard him say about the witness intimidation and stuff. And I was like, what? Like, that's not how that usually happens. You don't hear about witness intimidation and not having a dog in the fight. Okay, so he's not the one that's on trial for the intimidation charges. Like, it was with the Karen Reed case. Um, he's not. He doesn't. There's no connection. It's like, how do you connect the dots, right? You have to have you hear things. And I'm using this wrong, but think of like a chain of evidence. Like, you have to have that chain effect. You have to connect it to the offense, and you have to. The thing that got me, and I still think it is the root of all this, is that you have to look at the intent. It's intent, and it's not just offensive words. Now, he could have said, "Oh yeah, that's what I intended," and that may not be true, because, like, I intend to win the lottery, but I didn't even go buy a lottery ticket. So I mean, you have to. There's so the law is very, very, very broad. And you could study it your entire life and still get it wrong. We see that all the time. Supreme Court's overruling cases. Look at Plessy v. Ferguson. Segregation was, I believe that's the right one, where segregation equal, separate but equal. And then you had Brown versus Board of Education, where reversed. I may actually have those two backwards, but uh, the Supreme Court says the Supreme Court's wrong sometimes. It's it, this is not a Monday morning quarterback thing, and I don't think people should get all upset like they are and everything else. I think the most important thing, the very most important thing, if at the end of the day, Turtle Boy is found guilty and everybody says, "Oh, like, now I see it, it is guilty." Okay, if he's found innocent, okay, as long as the Constitution is rightfully applied and protected, that's what matters. And I don't care what side of the argument you're on. We should all be for the United States Constitution. And if you're not even American, you should be too, because we export liberty. Okay. We pump it out. We are, we're the pie factory of liberty. All right. So, anyway, I know this is probably going to cause a little more confusion, but I just want to give you guys an idea of what I'm thinking of. I've gotten a lot of new people into the channel. I don't like to see anybody. Well, you never want anybody innocent to go to jail. I really think that a lot of Turtle Boys' due process rights have already been. It's kind of suspect how they've been handled. He spent 60 days in jail, and now he's facing a lifetime in jail. I think the intimidation is on the government side. And hopefully you have uh, prosecutors shouldn't think that way. Judges shouldn't think that way. You should not think that the government's always right. And the problem is that the government has endless funds to fight you. It is there are a lot of innocent people that plead guilty because it's easier to do that and take a small punishment than it is to fight. Even if you win, you win your court case, you're financially ruined. They know it. Okay, bad actors know it, and that's what they do. And then, Godspeed to Turtle Boy. I hope that he is just, and uh, I hope that everything ends, in an amicable way. Other than that, guys, please, you're still here. Thank you so much. Please be sure and hit that subscribe button. It's free, doesn't cost you anything. And I love you guys. Go out there and do something fun for yourself. All right. Touch the grass and all that good things. Love y'all.